If you're the surviving spouse, it's important to remember that your deceased spouse has the ability to leave their property to anyone they choose. It's important to understand it's only their property that they can control, and they only control it if they had a will. If you're the surviving spouse and you believe that your deceased spouse has done something improper with either your property or your share of community property, California has a number of important safeguards for you. You'll learn why characterization of estate property is so important, what to do if you've been omitted from your spouse's will, the rights that apply or don't if there's been a divorce, and what to do if there was a questionable gift of property during marriage. The first issue you'll likely need to address as a surviving spouse is the characterization of the property. California is a community property state, and whether the property going through probate is separate property or community property is important to you. Let's start where there's a will. Your deceased spouse can only put through probate his or her share of community property and their separate property. What that means is your share of community property doesn't go through probate, but only if you take action to prevent it. You actually have to file a petition with the probate court to assert your claim to your share of community property in order to avoid that property going through probate. Now, you can do this fairly late in the probate process, but I don't recommend it. You're far better served to address this as early as possible in the process. If there is no will, then it's even more important that you pay attention to characterization because under California law, a surviving spouse gets all of the community property. If you don't pay attention to characterization and that property is determined to be separate property, rather than getting the whole thing, you'll wind up with either half or a third of that property. The second issue that can come up between spouses is where one spouse is simply omitted from a will. Now, this nearly always happens in a second or a later marriage, though it is possible for this to happen in a first marriage. The way it arises is this. The decedent has created a will, and the will simply doesn't mention their spouse. As a result, you, the surviving spouse, are not going to be left anything under the will. It seems completely unfair, and it is. So California has a remedy for you. If you're an omitted spouse, then a petition can be filed with a probate court in which you make the claim that you are an omitted spouse. You have to, of course, show that nothing's been left to you through the will. You also have to prove that you haven't gotten some other kind of substantial bequest. In other words, there might be property that passes to you by design outside of the will. It could be a life insurance policy, it could be a bank account. There's any number of ways to do this. But if what you've got is a true failure to plan so that you, the surviving spouse, are not getting anything, then you have the ability to stake your claim, and what you will get is your share of the estate as if the estate were intestate, meaning if your spouse died without a will. Now, I want you to be clear. If there is no will at the outset, then you'll never be able to assert this claim because it simply doesn't apply. If there is a will and you've been left out, then again, you want to get to this earlier rather than later and make your claim as an omitted spouse. The third issue that may confront you is if there was a divorce going on at the time that your spouse passed away. California has very clear rules about who is considered a surviving spouse and who is not. So I'm going to go through this so you understand where this applies. First of all, to be considered a surviving spouse, you have to be married to the other person at the time that they've passed away. If you are either divorced or legally separated, then you are not the surviving spouse. Here's how California determines which category you fall into. In order to prove that the marriage has ended, first of all, there's got to be a court order. It is very common for people to believe that because people are living apart, or the marriage was abusive, or the two members of the couple were emotionally distant, or any number of other social considerations makes them separated or divorced. Simply not the case. The first thing that's got to be shown is that there is a family law case that was opened. In other words, somebody went to court to either file for legal separation, for dissolution of the marriage, or both. The second thing that's got to be shown is that in that family law proceeding, the family law court entered an order. And that's either got to be an order that sets the date of legal separation or an order granting dissolution of the marriage. If either of those things have happened, then that's it. For probate purposes, the marriage is over. If there is an order setting a date of legal separation or a date of dissolution for the marriage, then you're not the surviving spouse. And if you're not the surviving spouse, that has important implications. It means if your deceased spouse left a will and it leaves everything to their spouse, you will not inherit. It means that if your deceased spouse did not have a will, so under intestacy you'd like to stake a claim, you can't. Under California law, you will inherit nothing because you are no longer the surviving spouse. And finally, if there is a will and that will nominated you as the surviving spouse to be the executor, that nomination is void. You will not be appointed as the executor of the estate. The fourth category is questionable gifts during marriage. And this almost always happens one of two ways. Either there's a gift of separate property from one spouse to another, or there's a transmutation of separate property into community property during marriage. Now, there can be good reasons for this happening, particularly where there's tax-sensitive estate planning. But if that's not what has happened during the marriage, then you need to look at this as a red flag, because that's exactly what it is. Marriage is supposed to be a partnership. It's supposed to be people sharing things. If what you see is a deceased spouse who got taken advantage of, understand that death doesn't stop anything. You still have the ability to pursue this through the probate court. Now, I'm not going to get into the law here because this will turn into an exposition on family law, and that's not what anyone needs. Understand that you should examine as best as you can what property was transferred, when it was transferred, and under what circumstances it was transferred. Take that information to your probate litigation attorney and let them analyze for you whether you've got an issue in your case. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.